Good evening. This is Laws 12062 Alternative Dispute Resolution. It's week 3 in term 2 for 2014. Tonight, a topic which is quite dear to my heart, which is mediation, the cornerstone of alternative dispute resolution in my view. Mediation is a growing mechanism for resolving disputes, and it's being used now in many different organisations for different ends. The reading in chapter 3 of Spencer is excellent, pages 49 to 84. I don't propose to run through that precisely, but what I'd like to do is consider what a good mediator should do during the course of a mediation program. Please feel free to interrupt, ask questions, or make comments as we go. So a mediation session, I'm assuming that there may well be many of you who are participants or have been participants in mediation, or indeed you might be mediators yourself. But assuming that that's not the case and you haven't been to a mediation, I'll run through the process step by step. But I'll do it from the perspective of the mediator. And you'll recall, of course, that one of your examination assessments is to step into the role of being a mediator and present on camera your opening. So we'll talk about that tonight as well. The first thing that the mediator needs to do is ensure that the environment, that is the room, the surroundings, the seatings, the visuals, are all in order. There's nothing worse than a mediator immediately failing to inspire confidence in the participants by having a disorganised room or taking them to a room that's already occupied or messy. So have your room set up. It'll show that you're prepared, ready to go, and organised and in control. Most times I'll set up the room with a jug of water and some glasses as well. Now, when the participants arrive, there's a critical moment where you can establish a rapport and credibility and to some degree empathy just in the first few moments. So the greeting, the meeting of the clients or the participants, the greeting that you give to them, the way in which you make them comfortable, the way you direct them into the room, guide them to their seats if that's what you choose to do, is all part of the mediation process. And I can assume that you'll understand why that's important. Once you've arranged for the seating, you need to start by providing an opening statement. But before you do that, just make sure that you're aware of the body language of the participants. It's of course not unusual for participants to dislike each other, sometimes quite immensely. There may be power imbalances as well. There may be circumstances where one party is obviously uncomfortable. So you need to address those issues to some degree. It might be simply a matter of taking a break from the outset, seeing if they need, a bit more time or whatever it might be. But anyway, keep an eye on parties' demeanour throughout the process, and particularly at the start. Now, during the opening statement, it's important that you cover some of the key mandatory aspects of mediation, and there are many other different things that you could include if you choose to do so. So some of the key points are the process that will be followed in the mediation, the fact that the mediation session is confidential, it's without prejudice, that the mediator's role is there to assist the parties in taking ownership of their own dispute and hopefully coming to their own resolution. That means, of course, that the mediator is not there to give advice to a party or either of the parties. And of course, there's this, the matter of confidentiality. At the end of tonight's program, I'll give you my take on an opening statement. It's just one variety that you might consider using. So assuming that the mediator has provided an opening statement and included in that a statement of the process, we then move on. There's a transition at that stage from the mediator, the focus of the mediator, away from the mediator onto the parties, not together, one at a time. And part of that intake process, part of the opening statement as well, might be to explain to the parties what you're going to do, and part of that might be that you've made perhaps a decision that the applicant will address first, followed by the respondent. You want the parties to understand that you're in charge of the process, but you're not taking ownership of the dispute. You're just providing the mechanism for that to occur. So, having established, for example, that let's assume that we've got a building dispute, a residential building dispute between a homeowner and a builder. The homeowner has brought an application to the tribunal alleging certain defects and asking for certain remedies. You might decide and have stated to the parties during the opening statement that the homeowner will go first. So the homeowner has an opportunity to outline his or her or their concerns. This sometimes can get out of control, but you need to keep it in control as the mediator. When I say out of control, parties come to the mediation often with a multitude of thoughts and a great deal of emotion. And sometimes people who, perhaps if they're less articulate or less used to a semi-formal setting, find it difficult to express themselves clearly. So part of your role as a mediator is, in a way, to let them go, to let them have their say within boundaries and not for too long, and then try to make something of it in terms of identifying what are the issues that are really of concern to the mediator, to the parties at that stage. So having invited one of the parties to provide an opening statement, the next stage is to ask the other party to respond with his or her or their opening statement. It's important that you've identified to the parties before they start that you wish to have the parties speak in turn and not to interrupt each other. To that end, you might suggest to the parties during the opening statement that you make that you would like them to make a note of any concerns, to raise them after the party has finished speaking and not interrupt the process. So once the two parties have had their opening statement, and during the course of that you're managing interruptions, we then go about trying to explore what is it in fact are the issues. Now it may be fairly obvious. The homeowner may be complaining about a roof that leaks and 2 or 3 other items, and the builder might be complaining about not having received full payment. So the agenda items sometimes can be quite obvious, but not always. And it's a matter of trying to identify the parties' interests and not necessarily their positions. And we talked about that last week. So the agenda item is a compilation of the important aspects that really should be discussed during the terms of the mediation. I generally aim to have perhaps no more than 5 agenda items, probably somewhere between 3 and 5 on average. And I try to restrict the agenda items to a word or 2 or maybe a phrase. So it might be that one of the agenda items is leaking roof. Another might be shortfall in payment. So you get the idea. You create that agenda to provide a focus for the parties in their discussions down the track. And it's important that you understand that even though I'm saying the mediator creates the agenda, it's slightly misleading, a bit of a misnomer, in that the mediator is recording or framing the agenda, but it's the parties who decide what the agenda items will be. It's just that the role of the mediator is to create some order, both in terms of the steps to be discussed and some order in terms of how we describe it, the protocols, if you like. And to do that, during that opening phase where the parties are providing their statements, after they've given their initial statement, the mediator may need to explore what the parties actually mean, may wish to clarify what it is that they're saying, may need to summarise what has been said, and make sure, of course, that nothing's been left out. Because having established an agenda item and trying to work your way through that agenda item as a mediator What you don't want an hour into it is for a party to raise out of left field some entirely different issue that wasn't discussed in the opening. That's not the way things should be. And in fact, if that does occur, as a mediator in controlling the process, you may wish to put it to a side and focus on the issues which were identified from the outset as being important. So you're summarising, you're exploring, you're effectively converting what was said by both parties as part of their reckoning of the dispute into something like a business agenda. And then go on from there. Any questions about what I've said so far? So far we've talked about setting the scene. We've talked about the opening statement by the mediator. We've talked about the parties' statements, one after the other, and the creation of the agenda items. Now, any questions? There's nothing on the chat. All very clear, eh? Okay, well, let's continue then. But do interrupt if you want. Having set the agenda, we now transition again into the matter of exploring the issues in a joint session. And this would have been explained to the parties that this is how you're going to do it at the outset in your opening statement. Now, a joint session is where you encourage the parties to now talk to each other. Up until then, a lot of it has been focused with you as the mediator. Now you're shifting the focus and you're trying to ensure that the parties are communicating between themselves as much as possible. You need to control the process. You need to ensure that it doesn't become inflamed or emotive or off track or irrelevant, all of those things. And we know through last week's session that some of the techniques we use are reframing and summarising. But most of all, very critically, during that early stage of joint session as a mediator, you are actively listening. You're being very careful to listen hard for clues that might assist in having the matter resolved down the track. Sometimes individual words or phrases can be very important and can assist you. So take control of the process, ensure there's an exchange between the parties, keep it under control, but here's the thing, you can't be bossy with it to any great degree, because if you start to become bossy with it, well, you're taking the dispute away from the parties and you're making it your own. So you've got to allow the parties some freedom, but you've got to rein them in if necessary. Now, how do you do that? Well, perhaps I could say this. From the outset, you've attempted to ensure that the parties have trust in you. They feel confident. Here's a person who seems to know what he's doing, in my case. Now, someone's got their microphone off, or am I mistaken? No, I can't see it. All right. So you've set the scene. You've made sure that the parties feel comfortable with you. Perhaps how it was described to me in one of the sessions I did was try to be their best friend during that mediation stage, their new best friend. Now, that's to both parties, so that people feel comfortable. And if you've got the authority and they feel that you're empathising with them to a degree, they will readily listen to what you say if you suggest that they're getting off topic, or we need to keep the emotions under check. All right, so you're actively listening, you're summarising, you're reframing, and we're trying to use open questions during that period of time. We talked last week about open versus closed. Closed question can be answered with a yes or no. Open question hands it over to the party to elaborate, to come up with the answer. So make sure that you use open questions. It is a trap for mediators on occasions to use closed questions as if they were cross-examining. So it's not a cross-examination session. You may have to deal with emotions during that time. There's always a risk of a walkout, and some techniques on how to deal with that. But oftentimes it's a matter of ensuring that the parties are reminded that they're here to try to resolve the matter, that this is their chance, that if the matter isn't resolved today, the dispute in many ways is taken out of their hands, put into the hands of a stranger, a tribunal member or a magistrate or a judge. So that's why you try to ensure that they come back to the table. That's if they're starting to consider walking out. So after you've been in joint session for a while, odds are that you'll probably want to go into separate sessions, private sessions we call it, or private caucus. And that literally means separating the parties so that they can then speak in turn to you as the mediator. Now, in your opening statement, you would have foreshadowed this. You would have said that this is likely to occur, so it doesn't come as a surprise to the parties. It might be that in that private, and also in the opening statement, you probably said that during those private sessions, anything which is said by the party to you as the mediator will remain confidential between you as the mediator and that party. And you won't pass on to anyone else. You won't pass on to the other side anything which is conveyed to you during that period of time. The importance of that is that the parties will then feel able to trust you and open up even a little more. Now, you've tried to get them to open up during that joint session, but sometimes they remain guarded on certain key aspects. And during that private session, there's a chance for them to maybe get some feedback, maybe for you to get some feedback from them, and also to discuss items that they didn't wish to discuss earlier. That can all be very useful in terms of trying to resolve the matter. So during that separate session, you try to meet with the respective parties for about the same length of time as each other. So you're trying to ensure that there's no perception of bias. You're debriefing at that stage. How's it going? How are you feeling about the process, etc., etc. You're encouraging them to come up with alternatives and maybe think about different ways to resolve the issue. There might be solutions that have not even been talked about that become available and are considered during that private session. And that can be explored. Not that you as the mediator will tell the other side, but you might encourage the party that you're dealing with at that stage to perhaps mention that type of thing, that possible solution, when we go back into joint session. So in a way, you're coaching, you're encouraging, and you're reality testing. You're making sure that any proposed settlement is workable, and you're also reminding the parties, what is the alternative to you if the matter doesn't resolve today? Are you really prepared to go to court? Do you have your expert witnesses? Do you have your money? Do you have the time? Are you able to cope with the stress, etc., etc.? So that's all part of reality testing in terms of what might happen if the parties don't resolve here and now during this session. But you're not doing it forcefully, you're doing it as their new best friend. After you've undertaken a joint session with both parties, you then reconvene in a separate private session with both parties. You then reconvene in a joint session. And here's where we hope to start to work towards a resolution, where the parties now start to go into settlement mode. And very often, through that second joint session, the matter is indeed resolved. Sometimes you need to discontinue the joint session, the second joint session, and go back into private session with both parties, and then go into a third joint session, maybe even a fourth joint session. Sometimes, once you go into separate private sessions, you remain there for the rest of the mediation, and sometimes you don't ever go back into a joint session for a second time. If that happens, the mediation then becomes what we call a shuttle mediation, where the parties are physically removed from each other, and you as the mediator move between the parties to try to assist the parties in coming to an agreement that way. So during that second joint session, you're encouraging a way that both parties can explore options. It may be that the parties are doing that themselves, or it may be that there are some roadblocks. There are a couple of techniques to consider what you do if there's roadblocks. It might be that you ask the parties to think about what are the alternatives to resolving the matter today. Now, you may have talked to them about that in the private session, but you're going to raise the issue again in joint session to see if anyone wants to discuss it. Another thing you can do is use silence, because people want to fill the void. So if there's a silence at a strategic time, suddenly one of the parties may surrender to that situation and start to talk. And by starting to talk, it may be that we can resolve the issue. Sometimes we brainstorm. We might encourage the parties to think about any idea at all that could possibly assist in resolving the issue. We don't ask the parties to think necessarily too much about it, but just get it out quickly. So it's almost as if you say, all right, for the next 1 minute, 60 seconds, I'm going to ask both of you to think about any possible solution, however silly it might be, and let's just get them on the table. Ready, go. And people start to think about maybe silly ideas, but it might just work. So that's another thing that you can use if there's a roadblock. Okay, once we've had the joint session, hopefully it's resolved and the matter is then reduced to writing. Depending on the model of mediation, that agreement may or may not be legally binding. In the very pure form of mediation, which is completely non-interventionist, such as used at the community justice centres, the agreement is not strictly legally binding. But most mediations are conducted in circumstances where it is intended that the agreement would be legally binding. There's nothing at all wrong with taking a break and allowing the parties to speak to their lawyer, their accountant, their financial planner, whatever it might be, their partner, in an attempt to get it resolved. So they're the sorts of things that we might put in the agreement. Okay, so you need to be persuasive, relaxed. You need to listen very carefully. You need to be light on your feet, as Judge Kingham, former Deputy President of QCAT, used to like to say, in order to resolve the issue. All right, now I've been doing a lot of talking. Now, I know there's a few things on the chat. I don't know if you're talking to each other. Does anyone wish to raise any questions that they've raised in chat? Yes, Carla?
Hi.
Hi.
I was wondering about the shuttle mediation. How quickly should we use that approach?
Mm-hmm.
I mean, how many joint sessions and separate sessions should pass before we say, okay, that's it, we're putting you both in 2 different rooms?
Sure. There's no hard and fast rule on that. It's a very good question. Sometimes you don't go into shuttle mediation at all. Other times it becomes, I guess, it's intuitive, but it becomes fairly obvious, particularly if there's a real risk of a walkout. It's one of the techniques that you use to say, all right, let's not inflame this anymore. How about we do this? And just keep them apart, settle them down a bit. Sometimes you go into shuttle mode right from the start. You don't have a joint session at all. And right from the outset that you might have a shuttle. That might be relevant where you perceive there's a power imbalance, or perhaps in a domestic violence situation where there are orders precluding parties from having direct contact with each other, for example. I hope that assists, Carla.
Yes,
thank you.
Thank you.
All right. Now, any other questions? So Faith was saying, are there occasions where the parties aren't amenable to a joint session? Yes, so hopefully that answers that one, Faith. Separate sessions, yes, weeks 4, 3.7. Thank you. Thanks, Faith. Okay. All right. So any questions generally? I know I haven't dealt with the text. The text is very good, but I think you can just read that for yourselves. All right. Well, I'll give you a sample opening. Is that okay? And I'm sure you won't just repeat this. You'll come up with your own opening for the assessment piece. Let's assume that I'm a QCAT member. Let's assume that it's a mediation, not a compulsory conference. And let's assume it's to do with a building dispute. I'll play act here and pretend that there are parties to my left and my right who are the parties in dispute. And my opening might be something like this. Welcome. My name is John Milburn. I've been appointed by the Queensland Civil and Administrative Tribunal to assist you in coming to resolve this dispute today. I congratulate you both on attending a mediation session. It's a voluntary process, but it's a very powerful process. It's a process that will allow you every opportunity to resolve this matter for yourselves. I am a lawyer, but I'm not here in that capacity. I'm not here to determine the matter. I'm not here as a judge or a jury. I'm here to assist you. At the moment, this dispute is your dispute. But if we don't settle today, it will no longer, in many ways, be your dispute any longer. It will go to the tribunal and a member will determine the matter, which will then be binding on you. So I urge you at this stage to endeavour to talk through the issues and hopefully come to a resolution. It may be that during the course of the mediation, it becomes apparent that a settlement will not be exactly what you want for either of you. It may be that you need to make compromise, and that's part of what this process is all about. It may be that you're not happy, but you're willing to undertake the agreement that you strike today, and I encourage you towards coming to that agreement yourselves. Now, this process is relatively informal. I propose to proceed on that basis. My personal preference is to use first names. Does anyone have a problem with that? Great. Well, look, let's just use first names. Just call me John. Are you authorised to make a decision today? Yes? You can make a decision? That's excellent, because it's important that we discuss, knowing that at the end of the day, at the end of this mediation session, the matter might be formally resolved. This is your dispute, and I urge you to take ownership of the dispute. Now, I'll tell you about the process. It's a confidential process. What that means is that anything that you say to each other today will not be available for use in cross-examination or in evidence at the tribunal if the matter proceeds further. Now, what I mean by that is this, that the process is designed to encourage you to make offers, to make compromises in the hope that we can resolve the matter. So rest assured that if, for example, you make an offer to settle, it's not going to be used against you. If you come up with some idea or compromise the situation, it can't be raised against you at a later tribunal proceedings. So speak freely, voluntarily, and I encourage you to think about ways that we can resolve it. I will invite both of you in turn to provide an opening statement. Now, it was your application, so I will invite you to make the opening statement. During that time, I would ask that you please allow him to make the statement without interruption. If something comes to mind, please make a note. There's some paper there, and raise that at a later time. Once you've completed your opening, I'll then invite you to provide your statement. And once again, while she is providing that statement, please make a note and don't interrupt. I encourage you to be respectful of each other, and please don't interrupt generally as we proceed, but I will encourage you to talk to each other during this mediation session. We don't have to stick to a rigid formula, but I do expect that after hearing from both of you, I'll identify some agenda items with your input, and that will form the business agenda of the proceedings, if you like. After that, we will go into a joint session. We'll talk about the agenda items progressively, and we'll try to at least understand each other's position, which might assist in coming to a settlement. Once we've completed that joint discussion, there's every likelihood that we'll then break into separate sessions, private sessions if you like, and during that time I will hopefully speak to both of you for an equal or roughly equal amount of time, and rest assured that anything that you say to me during that private session will remain confidential between us, and I won't disclose it to the other party. Once we've been through that private session, we'll probably come back into a joint session, try to explore some options, and hopefully come to a written resolution, a written agreement, which then can be made binding through the tribunal. I understand that these are to some degree emotional proceedings. I have read the material. I know that there's a lot at stake, and once again, I congratulate you on coming to this forum to resolve it. Now, before we start, do you have any questions? Fine. As indicated, if I could hear from you first with your opening statement. Thank you. Okay, that was a bit long-winded, but that's my take on an opening statement. Does anyone have any questions? Did anyone think that I missed out on anything? We'll have fun.
Pretty good.
Yes, sorry.
It was pretty good.
Oh, okay. Thank you.
You've obviously done quite a few.
I've done a few, yes. Thank you. But
you know, through the first couple of.
Yeah. Look, I had notes, and you could probably tell that, and there's nothing wrong with having some notes. So just have a few dot points. I wouldn't write it out though, because remember, you've got to try and maintain eye contact with the parties. So when you do your Zoom session, part of the assessment will be the perceived ability that you have to maintain eye contact. And you can't do that if you're reading. But you can have notes, but I would suggest probably just a few words here and there. I hope that makes sense.
Would you normally put in some...
Sorry? Oh, was that you, John?
That was me, yes.
Yeah, sorry, John.
I was waiting for Carla to go first.
Oh, well, it's all right.
Fine. Go ahead.
Okay, thanks, John. You can go, and then we'll go back to Carla.
Thank you. Would you normally put something in about what was discussed in the mediation being confidential unless agreed?
Sorry, during the private sessions, is that what you mean?
But during the whole session, would you say that all that was discussed in the mediation was confidential unless it will be discovered in a court process?
Yes, and I attempted to say that, but I probably didn't say it very well. But yeah, you're right. During that opening statement, you've got to ensure that the parties know that everything which is said during that process is confidential. And that's actually a little bit misleading, because there will be things that are talked about that are in the court proceedings already, which are public knowledge. But what I meant to say, or what we really meant to say, is that things which are statements regarding compromise or attempts to settle, that's all confidential and can't be raised in later proceedings. Does that clarify it, John?
Yes, thank you very much.
Thank you. Carla?
Yes, I don't know how to phrase that question, but my thoughts are concerning the assessment. What are the criteria that you'd be grading us on? For example, the opening statement, what we're going to include in it. You just mentioned that if we do eye contact with the parties or not. Are there any other stuff that we will be assessed on? For example, how relaxed we are, or? Yeah,
that's part of it, and it is part of it. The main assessment will be that you cover the basics, talk about the process. Now, I was remiss in that I didn't say that the mediation session might normally take somewhere in the order of 3 hours, so I probably should have said that. But just talk about the process, make sure that they understand that it's confidential, and make sure that they are authorised to make a settlement or come to an agreement. they're really the key issues. And also explain your role, that you're there not to make a decision. If you've covered those basics, even though your opening might be very short, you'll pass this part of the assessment. But if you want to do very well in the assessment, you'll add those extra things in, such as maintaining eye contact. I hope that answers your question, Carla. Thank you. But have fun with it. Don't be tired. You'll pass it easily if you cover the basics. All right. Any other questions?
One, just about assessment 2, please. When we pick a week and put our assessment up, say we had wanted to do last week's one, assessment 3. Is it now too late to do that?
No, that's fine. Yes, absolutely. You can still do that. Anywhere between weeks 3 and 12. And there's been a couple of questions about how I'd like it to be presented. So long as I can see it, I'm happy with that to occur. If I had a preference, it's probably that you upload it as a document. So if you're keeping your reflections, maybe keep them in a Word document as well and upload them all in just one document. It'll save me having to go through and check. But I would like you to upload these for all the students to see. Does that answer your question, John?
Yes, it does. Thank you very much.
Thank you. Oh, I'm pleased to hear. I'm pleased we're getting some questions tonight. Thank you. Anything else?
Yeah, can I just take you back to the brainstorming?
Yes, Ray.
And you spoke about brainstorming, just throw it open to anything. Don't you have to sort of set some boundaries in relation to that? Because I know brainstorming is an effective thing to get ideas out, but if you've got an adversarial, people adversarial to one another, and you're trying to sort them out, brainstorming, there's some danger to that.
Yeah, why do you say that?
Oh, well, if people in there, they've got lots of emotion and someone says something that the other person doesn't like, brainstorming, it can go bad.
Yeah, actually, I take your point. Just in that regard, I wouldn't use brainstorming at the start. I'd only ever use brainstorming towards the end, and probably at the stage where the mediation is just running out of momentum. So it's a way of picking the mediation up, but it's probably at a stage where they've already done their venting at the start. And if you've done your job well as a mediator, you've probably settled them to a degree where they can coexist. But yeah, you're right, brainstorming can inflame the situation. Hopefully, it'll go the other way and provide some options.
It's a good point you made about silence too, because I know that sometimes when you're speaking to someone and you're trying to get them to say something, if you just lean forward and tilt your head a little bit, they feel obliged to say something.
Exactly, yes. Asking questions and leave it at that. Wait for a response from someone. It's a good way to go. Thank you. All right, well, we might be getting close to wrapping it up. There's nothing on the chat line. No final questions. Thank you. All right, I'll stop recording.